Welcome everyone to our Freelancing 2021 series. Sorry, let me just get organized here. And today we're going to talk about a topic that is always of interest, which are legal basics that every freelancer or consultant or solopreneur should know. And I do want to say this is the third of our 4 workshops. A week from tonight, we're going to be talking about preparing to launch your first 90 days as a freelancer. And so that will be the last formal workshop we will have. I also want to talk, and for those of you who have been here previously, you know, that after that last workshop, we are going to be having our first ever Springboard to Launch Accelerator. And it's open to Temple University students, alumni, staff, and faculty. It features one-on-one mentoring during 3 interactive, very work-intensive sessions. So these workshops provide a number of information on what you should do, tools, philosophies, frame of mind. But in the accelerator, you're actually going to do it. You're going to write your positioning. You're going to write a plan for how you need to build your infrastructure. You're going to go out and sell and market and form contracts and gain agreements. So we're very much excited about this. And there will be 3 sessions, and then there's going to be a virtual exhibit and a dedicated website launch where everyone who's part of the accelerator will have a chance to present what they do to the Temple community and to the external Philadelphia community. And one of the big, let's say, needs that we always hear from people is, I need to let other people at Temple who maybe need a consultant, who need a graphic designer, who are looking for some type of design goods, I need to let them know I can provide that. And so this exhibit and website are going to start providing you the opportunity to become known within the Temple and surrounding communities. Okay, and a little bit more about applying to that. In the past, you've heard me say that you need to attend at least 3 of the sessions we've held. Because of a number of requests, another option is to watch the videos of at least 3 sessions. And those videos of prior sessions are available on our YouTube channel. You need to complete a very short application, and that portal is now open. And applications are due March 19th. So I would strongly encourage you, if you're interested, don't wait till March 18th to go check out the application portal. Go look at it now. It's relatively straightforward. You can begin completing it. And if you have questions, you can reach out to myself or Evan at IEI. After you submit an application, we're going to have an interview with a small screening committee. And then your agreement, if you get accepted, is that you'll attend the 3 mentoring workshop sessions and also the culminating website launch event. And if you have questions about any of this, you could put it in chat and we will answer it towards the end of the session. Okay, so I would like to introduce our guest.
I should have sent you a more recent picture.
Oh, that's okay. So we're very lucky to have with us this afternoon Sharon Irwin. Now, Sharon graduated with her law degree cum laude from Temple University. She now teaches at Drexel, but we're okay. We like to share our wealth, so no problem with that. She has worked for a long time representing cultural nonprofits, museums, foundations, charities, filmmakers, musicians, gallery owners. So her expertise is a perfect fit for everyone participating this evening. And her practice ranges from copyright and insurance advice, litigation, contract drafting and negotiation, which is a critical part of what all of you solopreneurs need to become expert at. All different types of things, all the way to public art and cultural heritage and website and database development and licensing. So without further ado, because she has a ton of great information that she will share with us, I'd like to introduce Sharon Irwin. And Sharon, I will stop sharing so you can now share your slides.
Okay, thank you. Thank you, Alan, and thank you all for attending. Also, I should mention, Alan, your the accelerator program sounds terrific.
Thank you.
So, sorry. Apparently, I have to mute it every time it comes in. My apologies. Anyway, thanks again for participating today, and I'm really looking forward to sharing with you some basics on legal structures, basic contract law, and some fundamentals on copyright and trademark law. It's a lot to cover in a limited time, so I will only briefly describe my background, which Alan really covered. I did start at a big firm, moved to a litigation boutique, and then since 1998, I've had my own solo practice here in the Philadelphia area. And while I work in a lot of different areas, one thing that's been consistent is I've always represented artists and arts organizations, cultural institutions, and nonprofits. Although originally, when I first started out in practice, I did so as a pro bono volunteer with the Philadelphia Volunteer Lawyers for the Arts. And I remain a volunteer today. I'm also on the board and on the executive committee. I'll be talking a little bit about PVLA throughout the program today, but I just wanted to highlight PVLA for all of you because it's a great, great resource from educational opportunities to full representation if you qualify. So as I said, I'll talk about it a little bit more as we go along. So now let me just open my presentation and sorry, the toolbar is hiding the start slideshow. There we go. And slideshow. There we go. Okay. Are you all seeing this okay? The slides? Yes? Okay. All right. Well, my objective today is just to review the basics of business structures, review some of the most important basics of contract law and negotiation considerations, and then talk about some of the fundamentals of copyright law, very briefly mention some things about trademark law, and then allow the time for questioning. So I'm just going to jump right in on business structures. One of the important things to remember is that business structures are creatures of state law. So the details will differ depending upon which state you're in. And I'm not sure, most of what I'm talking about today is Pennsylvania, and most states are similar, but just be aware that there are going to be differences in formalities and requirements from one state to another. There are certain key considerations for deciding on what sort of entity you should operate your business through. There are things like taxation. Do you want to be taxed individually or as a corporation? What about liability? Are you concerned about personal liability? Would you like to have some protection from liability? What's the duration of the business you want to operate? Is it, are you doing a one-time project? Do you want to run your own business just for as long as you want to or your lifetime? Or are you hoping to build something that will last beyond your lifetime? And then, of course, a very important consideration is management. How do you envision the management of your business? So with those backgrounds in mind, and you'll find this in all states, there are certain principal choices. First is a solo proprietorship, where you work for yourself. The second is partnerships, and they can be both general and limited, as I'll explain in a minute. You can run a business as a corporation, whether as a for-profit or a nonprofit, and now there's an opportunity for benefit corporations, which are relatively new. And then finally, you could be a limited liability corporation, which also can be either for-profit or nonprofit or a low-profit limited liability company. So let's start with sole proprietorships. The downside of sole proprietorships is that the owner has unlimited liability for the debts of the enterprise. So if you have assets to protect, such as a home, that sort of thing, you really want to think this through. And when you get to a final decision-making point, get the advice of an attorney and an accountant to make sure you're making the right choice for you. With a sole proprietorship, the management skills are generally limited to the owner, for good or ill, depending upon the owner's skill set. And all profits are attributable to and taxable to the owner. But on the plus side, they're taxed at the individual rate, not a corporate rate. So that can be a big savings. And another advantage to sole proprietorships is that they have low startup costs and relatively simple bookkeeping. And you should remember that nothing is written in stone. If you just start as a sole proprietorship, there's nothing to prevent you down the road from deciding you want to incorporate or you want to become a partnership. Now, partnerships under Pennsylvania law, and this is pretty much true, I would say, in every state, you either have general partnerships, which are by agreement, or you have limited partnerships that have to follow certain statutory formalities, and which consist of both general partners and limited partners. So both general and limited partners are generally not negligent for, or not liable for the negligent or wrongful conduct of the other partners. And each partner is liable for their own negligent actions and the actions of those they supervise and other partnership debts. So I thought it would be helpful to give an example of a limited partnership. General is just you're both partners. It's two general partners. You're basically equal owners, share equally in the debt and the business debts, but you're each responsible for your own conduct. With the limited partnership, a good example is if you were making a movie. With that, you might have the director, the writer, and the editor of the movie serving as general partners, but they obviously need investment money and financing and funding. So oftentimes the companies who invest the money into the movie production are limited partners. And as a result, their liability is limited to their investment. And they're also not involved in the day-to-day operations the way that the general partners would be. Then you have corporations, and again, I'm focusing under Pennsylvania law, but it really is similar from state to state. There are for-profit business corporations. These are probably the most demanding in terms of the formalities, what you have to file with the court, with the state, and reporting obligations, that sort of thing. There are C corporations and S corporations. There's no real need to get into that at this stage, but just know that there are different tax consequences and structural flexibility with each. Again, at decision-making time, you'd want some professional advice on that. And the real plus for corporations is that the liability of the owners, of the shareholders, is limited. Benefit corporations are a relatively new type of corporations, and they are organized for profits like a regular for-profit organization, but they also include a corporate purpose of creating a general public benefit, in addition to all their other business corporation activities and purposes. And they're permissible in about 35 states, including Pennsylvania. This requires a bit more reporting because you have to meet all the typical corporate formalities. And then you also have to provide an annual, this is in Pennsylvania, but most states it's similar, an annual benefit report describing your efforts to create a public benefit during the preceding year. And there can be advantages to that for you in fundraising and potentially on taxes. Oh, and I do have links there, and I understand you all have access to the PowerPoints for any of the links that I've given you. Limited liability corporations, they're helpful in that they do provide protection from liability, but they're a little bit more flexible and less rigid than the a corporation in terms of legal requirements. The LLCs can qualify for taxation as a partnership, which means that the taxes pass through to the individual members of the LLC. With an LLC, you have members as opposed to partners or shareholders. And then they can be taxed at the individual level, although you can elect to be treated as a corporation if there are advantages, be taxed as a corporation if there are advantages for that. And LLCs have become increasingly popular. And then finally, there's the low profit limited liability company, which again is relatively new, does not exist in all states. It is now permitted in Pennsylvania, and it's a hybrid between for-profit and nonprofit corporations. And the purpose of these L3Cs, they're called for short, is that they signal to foundations and donor-directed funds, much like benefit corporations, of an intent to conduct activities in a way that would qualify as program-related investments. So you have a double bottom line. There's a financial return, but you're also looking for a social benefit. And because of that, that may permit foundations and donors to fund certain projects or program-related activities that you're doing that qualify as providing a social benefit. I've already mentioned some of the factors to consider in selecting a business model. The first, obviously, is liability, which can be very important, individual versus limited or corporate liability. Corporations grant the greatest protection. As I mentioned, the shareholders generally are limited, in the event all goes wrong, to their investment in the corporation. The duration, death and taxes, you can't escape. And that's one thing you have to think about, when you're deciding what you want to do for a business, is how long do you envision it lasting? And then what is your concern about taxation? Do you want it taxed at an individual or corporate level, or some combination of the two, which is permissible with some of the business models? Another thing to consider, of course, cost we've mentioned, from sole proprietorships being the lowest cost to corporations costing the most in terms of filing fees and reporting and audits and things like that. But you also want to think about who's going to be in charge. Do you want that to be by agreement? Do you want that to be by statute, which would be the case with limited partnerships and various corporations? Do you want the members to be in charge if it's a limited liability corporation, or perhaps an executive committee of a group of the members? Or do you want your organization run and managed by a board of directors, whether for-profit or not for-profit, with the various fiduciary obligations that the board members would have to the organization? This is just a small chart I put together. I thought you might find useful. It's not intended as legal advice. It's just to give you a summary of some of the differences with the different types of legal structures you can choose and how they might differ on different factors that I've just reviewed. So I hope that's useful for you. Now, as I mentioned earlier, the Philadelphia Volunteer Lawyers for the Arts, and here's their website, is a fantastic resource for you. They do provide educational guidance. You might get individual representation if you qualify to talk to a lawyer about how best to set up and structure your business. And also, of course, they can give you help with contracts you may be involved in, litigation help if you qualify, copyright issues, trademark issues. It's really a good resource. And they have some good resources on their website, including they put together a really nice summary of COVID-19 topics and resources for artists, inventors, and arts organizations. So if any of you have any questions about that, such as, for example, the payroll protection loan program, which is now going into loan program 2, although if you did not apply in the first round, you can apply as a first-time applicant. And these are loans that, assuming you use to protect your payroll, including for yourself, if you meet the qualifications, the loans would be forgiven. So it's a really fantastic program. Another great resource is the Greater Philadelphia Cultural Alliance. Again, there's their website. I urge you, if you're not familiar with the organization, to check out its website. It offers a lot of advice on the website. It too offers a lot of COVID-related help. It also is an advocacy organization for the arts and culture sector, so you may find that of interest. And they've also been tracking what is happening in Philadelphia to the arts and cultural community as a result of COVID-19. And they're also putting together some great programming on racial equity and inclusion and diversity. They have some good webinars and things. So again, I urge you to check that out if you are not familiar with it. So that was very quick, but we do have limited time. So I'm just going to jump now right into contract law basics. I should first mention that, particularly for arts organizations, arts businesses, cultural businesses, you usually have 2 types of contracts, although they often overlap. On the one hand, you have your operative administrative contracts, such as, if you have a contract with the payroll company, or you rent equipment, or you hire PR consultants, all those things that help you operate and administer your organization. And then you have the programmatic contracts, or the services contracts, or educational contracts, which are those which cover the services or the work that you're providing. Contracts may, they can be a very formal, agreement of sale, but they also can include a project proposal, as long as it's signed by both parties. Commissioning agreements are a form of contracts, assuming that they're signed. And the basics of contract law, what you want to be sure you have from a legal perspective, is an offer, acceptance, consideration, and an intent to be legally bound. So the offer is the offer to provide services or to pay for someone's services. Acceptance, which must mirror the offer, is where you say, yes, I do want to buy your product, or yes, I will sell to you. But it's very important that the offer and acceptance mirror one another. Otherwise, you don't have a contract. What you have is an offer and a counter offer, and you just keep that up till you get the mirror between the two, which is called a meeting of the minds. Consideration simply means that all the parties actually receive value for what they are getting out of the contract. And then the intent to be legally bound is that, this is a legal contract and not what is often referred to as a social contract. And the easiest example of a social contract is between a parent and a child. If a parent were to say, if you graduate from high school with all A's, I'm going to buy you a new car, and the child does exactly that and then says, all right, I'm ready for my car. And the parent says, sorry, I really didn't mean it, or I can't do it now. It was just an idea. The child can't then sue the parent to enforce the agreement because it's a social contract and not a legal contract, which you could sue to enforce if someone breached what they had promised to do. So that's from a legal perspective, that's what you have to have. From both a legal and or practical perspective, you really need to be sure that you have the right specificity in your agreement. You know who are the parties, what's going to be done, when it's going to be done, where it's going to be done, and how it's going to be done. And that covers for both parties. You know, one party may be paying, the other may be providing services, but you really need to be specific about who is doing what, when, where, and how. I used to work with an attorney who liked to use the phrase Q-tips whenever she was reviewing a contract, and that was quantity. You know, what is this, one work of art? Is it a series? Is it a prints? Is it one design? Is it a whole PR rollout with different logos and publicity materials? What is the timeline? You know, when are things going to be done and on what schedule? The clear identity of the parties, of course, the price, which is very important, and then the subject matter. So that's handy if you're putting together a contract, just to keep in mind Q-tips, and it just helps you focus and make sure you're including everything you should. It's very important to think about risk assessment when you're going to enter into a contract. And that really involves strategic thinking, you know, what ifs. Okay, you're going to provide, let's say you're going to provide design services. What happens if you become suddenly ill? You know, what's going to happen if you can't meet what you've promised to do? What if the other party doesn't pay you when they say they will? What if there's a pandemic and you can't deliver what you had promised to deliver? So you really just have to think about, basically, it's really about what are all the things that can go wrong and how can I protect myself? And often if you ask the why you're entering into this contract, that can help guide your thinking. Like, why am I entering this contract? What is it doing for me personally and my business interests? What do I want to gain from it? Is it I simply want to be paid? Is there more to it than that? You know, I think this is a good, maybe it's a lost leader that I think will give me a lot of publicity or attention. So you need to think about all of those things. And then the most important thing is you need to understand everything that is in that agreement and ask questions if you don't. Sometimes there's a tendency to think, oh, I'm going to look stupid if I ask that question. The other side probably knows. Don't worry about that at all, because if you don't understand it, there's probably a good chance they don't, or they don't want you to, which is even worse. So be sure to ask questions. And this also relates to, you know, I have nothing against, you know, going on the internet and looking at other contracts as models or templates, but that's what you want to think about them only as templates. Never cut and paste and sign off of them without having gone through all the thinking of the factors and the considerations and the risk assessment, because unfortunately people do it a lot. But for one example, this was years ago, but I had a client who came to me after, it was someone who did software development work. And they came to me after everything had gone wrong. And so it's all right, well, you know, and they wanted to sue. All right, let's talk about that and whether it's worth it and the ways to do it. But first I need to see your contract. Well, lo and behold, they had just cut and paste a contract that said, if there's a dispute, you have to litigate in, let's say, Berks County. Well, neither of the parties lived or worked in Berks County. All of the services, you know, one was in Montgomery County, one was in Philadelphia. So right from the get-go, you have a problem, which is, well, if you don't sue in Berks County and sue someplace else, are you immediately going to be met with, whoops, this case needs to be thrown out because you're violating the contract, it has to be in Berks County. Or if you file in Berks, are you then hit with, this case should be thrown out because it has no connection to Berks, and despite what the contract says, it really shouldn't have been brought there. So right away, you're not even getting to the merits, you're getting lost in the weeds about where you should file suit. So just be sure you've read everything in the contract before you sign. You also want to be sure you've thought about how the contract can be terminated and who can terminate it, when, and for what reasons. So, for example, do you want a contract that you only terminate if someone breaches the contract? Either they don't provide the services they said they would, or they don't pay when they said they would. What happens if you are going into a contract with a much, much bigger operation and they say, well, we need the right to terminate for whatever reason we want to. And so your first reaction might be, oh no, well, that can't be right. But it may be there's a middle ground saying, well, okay, but I've reserved time and resources to get as far as we get in our relationship until you terminate. So I need to be compensated for that in some fashion if you're going to be able to terminate it for any reason and not just because I breached the agreement. And then when can you terminate? Okay, somebody breaches the agreement, they don't pay, on a scheduled payment, they don't pay it. Can you terminate immediately, or will your contract say, I have to give you notice of my intent to terminate, and you have 10 days to remedy it, cure your breach, pay me, and then we continue on our merry way. And if you don't, then I terminate. What's going to happen if you terminate with any existing work product? Or with the timeline or the payment schedule, whatever it may be. And then how do you terminate? Do you have to give notice? Must it be written? If written, does it have to be certified mail? And when is it effective? As I mentioned, is it effective? Can you just say, I'm terminating, you breached? Or is it 10 days after notice of an intent to terminate? So do think through all of those issues. And again, strategically, what ifs are, what might happen that I would want to terminate my agreement with this individual or this organization. Another clause that I really recommend that you always include in a contract is what's known legally as a merger clause. And basically all this is an agreement that says this contract is the final and definitive arrangement between us, the parties, and the purpose of this is to protect you and the other party from any arguments that, oh, well, there were some oral agreements we made before signing that are part of the agreement, or the oral agreements we made after we signed and they're part of the agreement. So this just forecloses it. And so that you say, this is it, unless we sign another agreement or an amendment by both parties that we're amending the agreement. So it does provide you with a good amount of protection. Warranties are always a big issue in contracts. Essentially, a warranty is an assurance, a promise, or a guarantee that a particular statement of fact is true and can be relied upon by the other party. Examples include, for creative professionals and entrepreneurs, people are going to want a warranty of originality from you, that this design is my original design, I did it myself, it doesn't infringe on anybody else's work, and I'm permitted to sell this to you or license it to you, whatever the agreement may be. Quality of work is another common warranty. That is, if it's services or a sculpture, whatever it might be, that this is free from defects, at least for a warranty period. You're not going to do it forever, and you also want to exclude wear and tear if if it's something that's exposed to the elements or things like that. But that's what you want to think about. If you're the one asking for the warranty, basically you want to think, how much time will it take for me to know that this really is working the way it's supposed to? And that's more common with services. Obviously with a design, that would be different. you want the warranty of originality, and maybe you want to be sure that they'll work in a professional and workmanlike manner, but you're not as concerned about defects in a design. One thing I would recommend, if you're the one seeking a warranty, when you have a warranty period, this is very common in like web development agreements, that sort of thing, that you figure out how long is it going to take me to be sure this website is up and running the way I want it to, and which we agreed it would. So that's your warranty period, but then you might want to say, oops, if there is a defect or a bug or a glitch found in the warranty period, once it's corrected, you want that warranty to start all over again, because maybe their fix is as bad as the original, but then you could get yourself out of the warranty period if it doesn't renew. Other contract clauses that are important to consider, and generally you should have them. The one I touched upon about the choice of law and the venue for disputes. This can be very important if you're here in Philadelphia working for a New York company and there's a dispute. Where do you have to fight it out? Whether it's arbitration or litigation, does it have to be in New York? Does it have to be in Philadelphia? New York could be very expensive for you. You generally want to dictate what law applies, since laws can vary from state to state. You don't have to litigate. You might want to consider, would it be a better alternative to say, if we have a dispute and we can't resolve it after good faith negotiations, we can go to alternative dispute resolution, which generates arbitration, which you can hire an arbitration organization to do it. PVLA at this time does not provide arbitrations or mediation, but I know the New York Volunteer Lawyers for the Arts do, if any of you are up in New York, and some of the others throughout the country might as well. Oh, I should mention that there are volunteer lawyers, attorneys throughout the country, organizations. So if some of you are in other states and locations, you might want to look into whether there's one in your area. The force majeure provision is something that has become quite a hot topic with the pandemic. It means simply superior force, but essentially it's usually in an agreement, and what it provides is that if there are conditions beyond anyone's control, you're excused from performance, at least for some period of time. So, for example, acts of God are the shorthand for things like storms and floods and all sorts of terrible things like that. And usually acts of war are included, and acts of terrorism, civil strife, riots, things like that. And what the force majeure provision usually says is, okay, if one of these events happen and it's beyond your control, we will excuse you from performing on the timetable that we agreed. And typically what these provisions provide is that you get a, if the interruption was, for 10 days due to flooding, you couldn't perform your services, and we thought we were going to get it somewhere in that 10-day period, you would then get those extra 10 days to fulfill your obligation. And it would apply to both parties. Many force majeure clauses did not specifically, in the past, reference disease or pandemics, or they might include certain diseases, but not pandemics and things like that. So there's been a lot of fighting about, who's excused from what as a result of COVID-19, depending upon what their contract provides. And so a lot of going forward contracts now specifically refer to events such as pandemics and viruses like the COVID-19. One other thing I should mention with the force majeure, and some of this is because of the experience of COVID-19, that some parties are now saying, all right, force majeure, we'll agree to delay, but if it's more than a year, then we can terminate the agreement. Either one party or both can terminate it, just because things can change so fundamentally over an extended period of time. So that's something to think about. And the last thing I will say is I've always liked this, this is attributed to Samuel Goldwyn, the movie mogul, that a verbal contract isn't worth the paper it is printed on. And that is really true. You're just asking for trouble. One last thing I would add, particularly from a lawyer's perspective, one thing we really hate, and it does happen more often than you think, but try to avoid it. A client will come and say, oh, we're really excited. You know, we've got this great project. We found the perfect partner to do it with. And now we want to draft the agreement. Can you do that? And it's like, well, sure, let's start talking about it. You know, timetables and the subject matter, or the who, what, when, and where. And they say, well, you know, we really need to get this done quickly. So we've already had them start the work. And there's no written agreement. And at that point, if you're the party for whom the work's being done, you've just had a big negotiating point knocked out from under you, because the person who has started the work knows you're under a deadline now, knows you're committing resources, and they're probably going to be less flexible than they otherwise might have been. So that's just my request on behalf of all transactional lawyers everywhere. Please talk to your lawyer before anybody starts performing anything under an oral agreement. And with that, I need to switch my slides out. So I'm going to, oh, I have to, oops, I apologize. I didn't pull it up yet. So let me do that.
Okay, and in the meanwhile, if people have questions about what Sharon's presented, please put them in the chat and we'll answer those at the end of the presentation.
Stop share, there we go. That's how I'm going to do it. Okay, now I can do this. My apologies for that. I always forget the sequence. Okay. I don't know if you can hear that. There's a very loud mailman outside my house laughing. I apologize. It's really loud. Okay. And again, I've got to move this. My apologies. Okay. So next I'm going to focus primarily on basic copyright law and then just touch on trademark law and give you some references and resources that I hope will be helpful to you. First, you should know that copyright law arises under the U.S. Constitution. It's found in Article 1, Section 8, and it reflects a policy decision by the Founding Fathers who said Congress shall have the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So the purpose of this was that as a policy matter, the Founding Fathers wanted to promote the progress of science and the useful arts for the benefit of the country and the people of the country. At the same time, they wanted to provide incentives for authors and inventors and creators to put the time and effort into creating their writings and making their discoveries. And so that's the trade-off, that the creator for some period of time has the benefit of owning the copyright, and eventually it will go into the public domain where everyone can use it. The one thing I should mention, it was really a fairly short period of time back originally, and over the years it has extended. So now I'm going to give you the copyright basics today. You should know that the copyright law today is a law that was enacted in 1978, although there have been some amendments since then that have added the Visual Artists' Rights Act and the like. But everything I'm telling you about today is the current requirements. If for some reason you end up having issues with a copyright that precedes 1978, things are going to be different, and it can be complicated depending upon when the copyright or the work was created before 1978. If that's the case, you're probably going to need some advice. So maybe you can go to the Philadelphia Volunteer Lawyers for the Arts. But anyway, under copyright in the United States today, copyright exists from the moment of creation. You create it, you own the copyright in it. You're not required to register it with the US Copyright Office, but you are required to register if you wanted to sue someone because they infringed your copyright. So you have to consider that factor when you determine whether or not to register. In addition to being able to sue, there are other advantages to registration. First of all, it's relatively inexpensive. If you do it electronically, it's $45 for an individual creator. It's $65 for co-owners or work for hire, which I'll talk about in a little bit. And if you want to file by paper work through the mail, it's $125. Registering your copyright also provides you with some legal presumptions, including that you have a valid copyright. So if someone were to sue you, they have to overcome that presumption. So it's harder for them than it would otherwise be. You also have the right, if you register, to statutory damages, which can be very important because sometimes it's difficult to prove what your damages have been, financial damages have been as a result of infringement. So this is a way for you to obtain damages in any event, even if you have proof difficulties. And then importantly, if you sue because someone infringed your copyright and you win, you can be awarded attorney's fees. The typical rule in the United States in litigation is that each party pays their own attorney's fees. But there are certain exceptions which, like copyright law itself, arise from policy decisions. And here in copyright, under copyright law, in the Copyright Act, Congress decided, we think this is really important. We want to protect copyright. We want to support creators and inventors. So we think that if somebody infringes their copyright, we want them to sue. We want people to know that copyright's important and you need to abide by it. And therefore, we're going to award a successful litigant their attorney's fees as a way of encouraging them to bring the lawsuit, whereas they might otherwise think, I can't afford it. And they may be able to get it on a contingency fee basis, with an attorney agreeing to front at least the cost, which you'd have to pay back, but it can be very helpful. Another area where we have that kind of policy trade-off is in discrimination litigation. Often in discrimination lawsuits, again, Congress said we do not want people discriminating, and we want people who are discriminated against to bring that to the public attention and to obtain damages, and there are any other legal remedies such as reinstatement, things like that. And therefore, if someone's successful in bringing a discrimination lawsuit, they can be awarded their attorney's fees. Then copyright notice is not required on a work you create, but it's certainly a good idea. If nothing else, it puts everyone on notice that someone does claim copyright in this particular work, and it also gives them a name to follow up on if they want to get permission to use or license your work. Well, there we go. The US Copyright Office site is very good and it's user-friendly. So this is the its website address. Particularly, I'm giving you the one on the copyright registration portal, but they also have a lot of publications that are a page or two that talk about different issues under copyright law. So I encourage you to check that out whenever you have copyright questions. It can be a really good place to at least start and figure out what your issues might be and where you might go. Another important point about copyright, which sometimes people don't realize, is that copyright protects the expression of ideas, but not the ideas themselves. So it's just copyright protection for an original work of authorship does not extend to any idea or any of the other things listed in this, which you can read, unless it's been reduced to some expression, some tangible means of expression. So an example to give you would be an idea if someone says, you know, I think it would be a great idea for a movie to have it be about a young nun with a great singing voice who's in the convent but probably really doesn't belong there. And so the Mother Superior decides to encourage her to take a governess job to see where things might go. Well, that's just an idea. You're not going to be able to copyright that. But it's a continuum. So as that gets more and more detailed, down to someone writing down a script for the song and music, then you've got your expression of an idea. And things can be, you know, sometimes it's not as easy to tell quite where you are. It's not always as clear cut. Are you specific enough with your expression of the idea that it's reached the point that it is copyrightable, or is it still more in the idea phase? So that's something to consider. But if you're going to share ideas for work that aren't at the point where you can protect them by copyright, you can always consider a non-disclosure agreement with another party, and you can protect yourself that way. So that's beyond the scope of today's webinar, but I did want to mention that. Facts are not copyright protectable. This was hashed out back in the 90s with telephone books. And basically what the court said is, no, the Constitution requires some modicum of originality. And it doesn't have to be much, it truly isn't, but there has to be some. And what that does is reject the argument that somehow the sweat of the brow should be protected. That, you know, it was a lot of time and effort in those days to gather, you know, everybody's name and telephone number and address and put it together in a book. But the court said, no, there's just no originality with that. You can, however, have, while you can't copyright facts in a database, the individual facts, the way you put them all together and what you choose to include in things may be copyrightable. The subject matter of copyright is, again, this relates to original works of authorship fixed in any tangible medium of expression, now known or developed later, from which they can be perceived, reproduced, or other ways communicated either directly or with the aid of a machine or a device. I listed here so you'd have it, but works of authorship include, they're what you would expect: literary works, musical works, dramatic, pantomimes, choreographic works, pictorial, graphic, sculptural works, motion pictures, audio videos, sound recordings, and architectural works. This is very important as creators of intellectual property for you all to know if you don't already, and that is the exclusive rights of the copyright owner, because really copyright ownership is a bundle of rights that the owner has. Sorry about this toolbar. Here we go. It'll be better down here. Because it gives you the right to do and the right to authorize others to do any of the following: reproduce the copyrighted work in copies or phonorecords, prepare derivative works based on your original work, and distribute copies or phonorecords of the copyrighted work to the public by sale or other transfer of ownership or by rental, lease, or lending. So what this means is it gives you additional sources of revenue. So let's say you create a work of art. You can sell the work to a purchaser. Let's say you sell, here's, you know, I really like this painting, I want to pay you $1,000 for it. And you say, fine, and you sell them the painting. Well, all that purchaser of the artwork owns at that point is the painting. You still retain the right to make copies of that work, you know, to make prints if you want, to make derivative works, you know, other, you know, if it's a pictorial work, to make a sculptural work out of it, to, you know, to use the image on merchandise, coffee cups, scarves, t-shirts, whatever. So think about that. And now the person who purchases the art may say, and particularly with graphic designers, you may get this, they may say, no, we need to own that logo because we plan to use it for years and years. And, you know, we wanted to associate it with our work or our services. And so that's perfectly fine, but that's where you want to say, well, all right, but that means I'm going to lose some opportunities I would otherwise have. So you're going to need to pay me more for that. And same with any of the other derivative works. And sometimes you can reach a compromise, you know, to say, all right, well, you can, you know, I'll agree to assign you an exclusive license to do certain things, and you're the only one who will get that license. But there are other things that, you know, that I might be able to do, and you can negotiate it from there. So be creative about that as too, about how you might maximize your intellectual property for your own benefit. Oh, let's see. Oh, and I'm sorry, I didn't hit all the buttons. So these are the other rights, and again, you have access to the slides. But these are all the things that you would expect, you know, that you can do as a result of it being your work. And you don't have to give up your ownership to do any of these, to allow someone else to do them. Oops, sorry about that. Here we go. Yeah, this is what I just went over, that the ownership of copyright is distinct from ownership of the material object. And copyright ownership is not valid, the transfer of it, unless it's in writing and signed by the owner of the copyright or their duly appointed authorized agent. Today, works of copyright, and again, this is if they're created on or after January 1st, the basic rule is they exist for the life of the author plus 70 years. Works made for hire exist, and I'll talk about that very briefly in a minute. They exist for 95 years from first publication or 120 years from creation, whichever is shorter. And as I mentioned earlier, the duration of copyright pre-1978 is complicated because different acts were in effect at different times. Works made for hire, you know, usually the ownership of copyright is best in the author or author of the work, but there are two exceptions. Works made for hire, and that's where it's a work created by an employee during the course of their employment and within the scope of their employment. And the other is you can certainly agree that it's a work for hire in writing. Although I will caution you that a work for hire, let's say you're commissioned to do something, a work for hire only exists in these 9 categories automatically if the parties expressly agree in their writing. I mean, they have to agree in a written instrument, but it relates to a work that falls within or is commissioned in one of those 9 categories. So if you're doing something that's outside of that and you're not an employee and somebody really wants to own the copyright, what you're looking at is an assignment of copyright at that point. To assign, you would assign your ownership to them. It's important to know what is within the scope of employment for purposes of a work for hire. It's a work creating during the time or for the specific objects for which you're employed, and created under conditions subject to the employer's supervision and control. Surprisingly, you might think whether work's done during working hours or at home, and whether the employee used the employer's facilities or personnel is not in and of itself dispositive. Those are important factors that people would look at in the event of a dispute. But before I sum up, the one thing with employment within the scope of your employment is if you're doing design work for an employer and you're hired, you're an employee, not an independent contractor, and you do something that they wanted you to do that's within what you're being paid for, that's going to be a work for hire. But if in your own time you're making a movie or writing a novel, or even depending upon whether you have a non-compete agreement, doing design work that has nothing to do with your employer, then you would own that copyright. It's really that which is in within the scope of your employment. As you can see, Mark Twain famously said that there's only one thing that's impossible for God, and that's to find any sense in any copyright law on the planet. And it really is true. But if you work your way through carefully and use the resources out there, from the Copyright Office to volunteer lawyers for the arts organizations, and really thinking through issues, you'll manage to get your way through that. And last but not least, I'll do this in a minute. A trademark, for anyone who doesn't know, is a word, phrase, slogan, design, or combination of those, one or more of those things, that identifies the source of the goods of one owner of the goods or creator of the goods, and distinguishes them from the goods of another owner or creator. It's a brand, like McDonald's. McDonald's is out there. If you see the golden arches and the McDonald's name, you're going to get a McDonald's burger, and it's distinct from Wendy's burger. And it doesn't necessarily have a connotation of, that means it's excellent. It just means it is the same and it's consistent. It's that brand. A service mark is the same thing, but it identifies the source of services, such as design services or landscaping, that type of thing. The U.S. Patent and Trademark Office has some really good, very short videos on trademarks for anybody who's interested in this subject. And I think they do a really nice job. They're short, and there's a whole series of them. And so I would suggest, if you have a question like, gee, am I creating a trademark? Should I have a trademark? What do I need to do with a trademark? That you check out this particular site. And that is it for me. I know it's a lot of information. I hope I didn't talk too fast, but I wanted to fit it all in. So thank you for being so attentive.
Great, Sharon. Thank you. If you wouldn't mind stop sharing, I am going to put up a link. We're going to give Sharon 2 minutes to catch her breath.
Thank you.
What I would ask is if everyone could go to, either scan the site, if you could see that, or if not, I can also put in the chat. Let's go to the chat. I just sent you the link for the survey. And if you could just take 2 minutes and fill it out honestly. Oh, look at that. Evan did it before me. That will allow us to understand how to constantly improve our products.
Am I able to, I can't access the chat yet, can I?
No, I'll read you the questions.
Ah, okay, thank you.
I just want to give everyone another minute to complete the survey. And feel free to add any questions to the chat. So also, just to everyone here, you'll see accidentally I sent you earlier the Springboard to Launch registration form link for the accelerator. So feel free to click on that, and if you're interested, to begin filling that out. There is a question about how you could get these slides. The video will be available probably within a couple days on our IEI YouTube channel. And we will also make the slides available. So we will, and Evan, if you want to chime in, only because I'm forgetting how, but we will most likely send you a link to access the slides in a folder. Okay. All right. So Sharon, a couple questions about contracts. So if I'm doing something and I provide a proposal to a company or whoever, a family, and they say, fine, I agree via email, is that a valid contract?
It can be, but I wouldn't advise it. You end up getting into what is called the battle of the forms, because what you have there is they say, I agree, but it's so vague, it doesn't have the requisite specificity. So down the road, they said, well, I agreed to the purchase price and that worked, but I didn't agree to that part or this part or that part. So I would not rely on that. Although now you can do, you can have people electronically sign the agreements and have that enforceable. There are different ways of doing that.
Okay.
So, but no, I wouldn't rely on an email that just said, great, I agree.
Okay, all right. So then that was going to be my next question. If, sometimes you cut and paste an electronic signature just on an email or a Word document, is that a valid, or I guess it's Adobe does these, where you could legally sign it. Is one more safer and more legit than the other?
Well, you just want to be sure that your agreement provides that you can do that. Another thing sometimes people do is say, this agreement, many of you may have seen that this agreement may be signed in counterparts, so that instead of both people signing the same agreement, the same piece of paper, each signs the contract and together it is a binding contract. But you want to say that that is permissible.
Okay. Okay. So I have a question here from William. And William, if I don't ask it correctly, you can unmute yourself. So it seems like in the area of copyright and regarding YouTube, how long can I use a recording during a video? So William, help us with clarification. Are you saying within a video you're doing, how long can you use someone else's recording in that?
Hi, how are you doing? Yes, I'm referring to that because I have a YouTube channel, but I have some copyright claims, and I don't know how long can I use another music from other composer, for example, or artists in my video. Sometimes I'm talking about, for example, 20 seconds or 25 seconds. How long can I use that recording to don't be a copy claim, like a copyright claim, or should not use it at all?
Unfortunately, there isn't a nice cut and dried answer, that, okay, 8 seconds is okay. The safest thing is to get permission, assuming, it's something that's not in the public domain. As a practical matter, if you used a little bit and it wasn't distinctive, maybe that doesn't matter. But I'm trying to remember, there was one lawsuit and it was just like a 5-note opening to a song. And it was so
George Harrison, My Sweet Lord, I think.
That was one. And then there was another one with the, about the racer champion. Anyway, it's so distinctive that they said, no, you're infringing on the copyright. It's not fair use. Now, I didn't get into fair use because we would have been here till tomorrow. But it's okay sometimes to use some of a work, but there's no hard and fast line about this much or that much. It's basically, are you competing with the owner? So you're interfering with their market. Are you doing it for commercial or non-commercial purposes? Is it educational? There might be circumstances where the facts are such you won't be viewed as infringing on the copyright. But it's a very gray area, and it's always, it depends. You really have to look at how much of the work of the other person's work is being used and how and for what purpose. And even then, most lawyers, when they're presented with it, they'll say, well, it really depends. That might be considered fair use, but I can't guarantee it because the courts are all over the place on that. So what you want to do is tread carefully. And of course, one of the easiest things to do is to ask permission.
Yeah, there are some, for example, I want to use Stravinsky pieces, for example, and he's dead. But there are a lot of publishers that have their music and a lot of orchestras that have their music, his music too. And but sometimes I'm putting those pieces there, and they are just there are a bunch of like companies that are like claiming that it's theirs.
They own it.
So I have that problem. And for example, the video is like 15 minutes, and I just use that for 1 minute, and then I cannot monetize that video because of those 2 minutes, things like that.
Right. And I mean, their publishers are pretty sophisticated about monitoring YouTube and other things, other platforms, and to get things pulled down if they think it's interfering with their copyright. So it's tough. You may want to, there's two solutions. One, you may want to look for works that are in the public domain. You don't have to worry. The other thing is, I don't know if any of you are familiar with Creative Commons. You heard of that? That is, Lawrence Lessig started it. Just Google Creative Commons. And it's a place where you can agree that other people can use your work in certain ways. So I've never used it for music, but I've used it for images. In fact, one or two in the slides, you'll see underneath it, it gives the name of the author or the creator, and then it says it's a CC 2.0 license. And what that means is that artist or photographer, whoever, said, I'm willing for other people to use my image under these circumstances. So sometimes they'll say only for non-commercial purposes, so I can use it for educational purposes and I'm not making money from, or as long as I'm identified and they don't alter the image, but they can use it. So you might want to check out what musical resources might be available on Creative Commons, because they're always growing and expanding. But other than that, it's get permission if it's still under copyright, or look for things that are in the public domain that copyright is expired, assuming it ever existed at all.
Great, thank you. Another question, and then we'll see if we have any others. Let's say I'm marketing consultant, and I have a certain methodology that I have utilized, and it's not common. I created it. It may not be rocket science, but I created it. It's very useful. Clients like it. Can I copyright that?
What are the specifics of it again? I just want to be sure I understand it.
Well, so let's say it's a way of, testing a product, testing the appeal of a product. And, it's just a series of questions I ask, and maybe a certain way I show an image.
Well, you might be able to get a copyright if your questions are, it's really something unique. It's not just a form. You can't copyright a form. So if they're just sort of certain questions that, anybody could ask, and, you're not going to get anywhere with that. But if you put things together, like with the questions, and it's a whole, like, here's my it's my content, here it is, this is unique, it has a modicum of originality, so you might, but it's another, it depends.
Yeah.
That would be a harder, obviously a harder one than, you know, a work of art or something, or a design, something like that. You'd have to give a lot more thought to it, and, you know, it would really depend on exactly how you did it. And but it certainly is possible. And don't call it a form, whatever you do.
Right.
Not the testing form.
Very good. So any other questions? If you do, quickly put them in chat. Is it important to always consult a legal professional? And can you write your own contracts, or is that ill-advised?
Well, obviously, I always think you should have an attorney look at a contract. However, that being said, they're expensive. But one partial solution sometimes you can do is perhaps, I mean, you could, this is a way to work with attorneys to kind of try to keep your costs down. One may be you draft it and then have them review it. So that's one way of doing it. Another way would be to say, look, this is the kind of service I provide or the work I create, and I would like you to create a template that I can use. You know, the prices may vary, the milestones may vary, the timeline may vary, but, you know, I'd like you to put, you know, talk to me, figure out my business with me. We'll work, you know, work collaboratively and get something like that so that you can use that and don't have to consult with the lawyer every time. Realistically, are there people out there drafting contracts without lawyers looking at them? Yes. Those are the situations where you can get into trouble. I would say, you know, if you're really debating and, you know, money's really a problem, or you can't get a pro bono counsel, you know, what's involved? You know, is it a very small contract? You know, what's your risk going to be? And the bigger your risk, the more you really want to consult with an attorney. That would be my advice.